morning and welcome to PV Legal's daily newsletter. Can a court of law create a criminal offense? And can police refuse to register an FIR simply because the accused happens to be a public figure? The Supreme Court of India has just answered both questions, definitively, emphatically, and in a judgment that every lawyer, every citizen, and every police officer in this country needs to read. The case is Ashwini Kumar Upadhyay versus Union of India, Writ Petition Civil Number 943 of 2021 and connected matters. The judgment was delivered on April 29, 2026, by a division bench comprising Justice Vikram Nath and Justice Sandeep Mehta of the Supreme Court of India. The dispute arose from a batch of 13 writ petitions and several special leave petitions seeking directions to enact anti-hate speech legislation and ensure enforcement against communal incitement across India. The petitions were triggered by two developments. First, the Law Commission's 267th report of 2017, which had recommended specific provisions for criminalizing incitement to hatred. Second, a wave of communally charged public speeches during the COVID-19 pandemic, which the petitioners alleged targeted religious minorities. Additionally, in a connected criminal appeal, a complaint had been filed against a union minister and a member of parliament for speeches allegedly promoting communal enmity. When the police failed to act, the complainants approached the magistrate under Section 156(3) of the Criminal Procedure Code for a direction to register an FIR. Both the trial court and the Delhi High Court rejected this, holding that prior government sanction was required before any direction to investigate could be issued. This rejection brought the matter to the Supreme Court. The court addressed four central legal questions. 1. Can the judiciary create new criminal offenses in the absence of legislation? 2. Is the field of hate speech legislatively vacant? 3. Do existing procedural laws provide adequate remedies for non-registration of FIRs? And 4. Is a continuing mandamus warranted for ongoing supervision of hate speech enforcement? A fifth and equally critical question was addressed in the criminal appeal. Does the requirement of prior sanction under Sections 196 and 197 of the Code apply even at the pre-investigation stage? On the question of judicial legislation, the court was categorical. It held that the creation of criminal offenses lies exclusively within the legislative domain. The doctrine of separation of powers under the Constitution does not permit the judiciary to prescribe new offenses or expand criminal liability through judicial directions. The Vishaka principle of courts filling legislative vacuums was distinguished. Where Parliament has already occupied the field, there is no vacuum to fill. On hate speech, the court found that Sections 153A, 153B, 295A, 504, and 505 of the IPC adequately address the problem. The issue is not the absence of law, but the failure of enforcement. On the critical question of prior sanction, the court set aside the Delhi High Court's erroneous view and declared authoritatively that the requirement of sanction under Section 196 of the CrPC operates only at the stage of taking cognizance, not at the anterior stage of directing investigation. Not at the anterior stage of directing investigation. A magistrate directing an FIR under Section 156(3) is not taking cognizance. The bar does not apply. The practical message for practitioners is powerful. When your client's FIR is being blocked on the ground that no prior sanction exists, the Supreme Court has now made it clear that ground does not apply at the investigation stage. File your Section 156(3) application. The police cannot hide behind procedural shields at the threshold of investigation. For the full legal analysis of this landmark ruling, subscribe to PV Legal's daily newsletter. This is your host, signing off for PV Legal's daily newsletter. Stay informed, stay vigilant. Thank you for watching. Good day.